Everyone that's listening in. Welcome to our webinar. My name is John Mashney, and I am an attorney at Foster Swift. Today's webinar is part one of a two-part series regarding 5 key legal considerations for every single software transaction. We want to remind you that this webinar is for information only, and the information provided does not constitute legal advice. Furthermore, participating, viewing, or listening to this information does not create an attorney-client relationship. You should not act on the information without consulting an attorney. Now, during the presentations, please feel free to type in any questions you may have. All the questions will either be addressed at the end or in the follow-up materials if we don't have time. And in addition, each speaker's contact information will be available on the slides. Now it's time to get started. First, a great software rollout can really be harmed if you don't pay attention to these 5 issues. And more importantly, there could be significant costs to your company if even one of these issues is not handled properly. So let's jump right into our first presentation. Iris Linder is an attorney at Foster Swift, and she has worked with numerous technology companies, specifically with critical issues regarding non-disclosure agreements and confidential information. Here's Iris.
Oh, thanks, John. Non-disclosure agreements can be used in a lot of different contexts, and today I'm going to focus on the use of the non-disclosure agreement in the context of a software build. My focus will be on the company side, which would mean where a company is either building software in-house and they have employees or hiring employees who will be working on it, or alternatively if the company is hiring an outside developer as a contractor.
Iris, what do you mean by the term non-disclosure agreement?
Well, first of all, I'm trying to move this slide and it's not working. Why? Oh, technical difficulties, sorry.
As Iris gets the slide pulled up about non-disclosure agreements, she's going to explain here coming up what really that term means.
Sorry, folks, it worked and we were practicing. Okay. So talking first about what does the non-disclosure agreement, what is it? First thing I want to mention is that it goes by different names. We're calling it a non-disclosure agreement. That's a really popular term. It's oftentimes referred to as an NDA, which is the acronym. Not so often an actual document, but it's just people talking about it. And then also it's frequently called a confidentiality agreement, and you will see an agreement that's called a confidentiality agreement. It's the exact same thing as in the non-disclosure agreement, just has a different title on it. So generally, what a non-disclosure agreement about is an agreement to hold certain information in confidence.
So Iris, when should a company or an organization look into using a non-disclosure agreement?
Well, the first part of the analysis is what confidential or proprietary information is going to have to be disclosed to the developer in order for the developer to complete the job. And rule number 1, notwithstanding what you do in your agreement, is that you should try to limit the information you share to that you absolutely have to share in order to get the job done. But then if you've done the analysis and you've decided that there really is information that you shouldn't disclose, perhaps it's because if that information was shared with a third party, a competitor, it might put you in a competitive disadvantage. Perhaps it's because you have confidential information of your customers that the developer is going to have access to. Whatever the reason is, if you are going to have to disclose confidential or proprietary information, then you should get the NDA signed before you share any confidential or proprietary information. In many cases, if not most, that's going to be as early as when you describe the concept or the project goals.
So Iris, why do you get that NDA before you actually share the information?
The very most important reason is you need to have a clear understanding with the developer, because they may have already shared it before it crosses your mind that you should get an agreement, and you could already suffer the harm. And there are also sort of legal consideration issues of whether you're giving them value for the confidentiality agreement, the non-disclosure agreement, that would not arise at the beginning of the project, but might arise if you deferred obtaining the agreement until later. The bottom line is it's hard to get the cat back in the bag. So the other comment I would make generally is that if the developer may have to share their own confidential proprietary information with you, and if they do, they may ask for a mutual non-disclosure agreement. You would never enter a mutual non-disclosure agreement with an employee ever, but with an outside contractor, it's possible that you would. You would need to talk with them about sort of the merits of their position, of whether they really will be disclosing confidential information of their own. And if you decide that it's a valid concern, I would never resist entering into a mutual non-disclosure agreement. The beauty of it is it creates a mutual trust from the very beginning of the relationship.
So now, what do you mean by the term, or when you say confidential information? What does that mean?
Well, the way I would frame it is that the first and most important aspect of the confidentiality agreement or non-disclosure agreement is to define the confidential information that is encompassed or covered by the agreement. And so that means you have to carefully analyze, as I mentioned before, what confidential information is going to be shared and will have to be shared. A lot of companies, if not most, are really comfortable with very broad definitions of confidential information. And the reason that they're so comfortable with that broad definition is that they feel like, oh, we need to cover all bases. Oh, we need to be really, sure we've got covered, unearthed every rock and everything is in there. But there's a problem with that approach. And I will say also, a lot of times it's because they pull something off the shelf or off the internet, or that they've used on another deal, and they don't give the thought that is really appropriate for determining what confidential information needs to be protected in this particular circumstance. So the result of that is you end up with some inherently ambiguous language. It's so broad that determining what did you really mean and what was really important is very problematic, and that can, again, create the problem of the developer didn't understand what you're talking about, and so they disclosed something they thought wasn't confidential, which in your mind it was confidential, or it can create a problem if you try to pseudo-enforce, and the judge is going to look at it and go, but I don't understand how I can just decide from these words what was confidential. And the other thing I found, particularly in this community, is that developers tend to be really hypersensitive around the issue. They like to, most of them, by personality, in my opinion, like black and white, which is, of course, what coding is all about, and aren't comfortable with gray. And they want to know which side of the line they're on all of the time. And they want to know also that information that they think everybody knows anyway isn't included, and that you, as the company that's contracting with them, understand that they couldn't possibly restrict themselves to certain aspects of information in terms of the disclosure obligation. And so in my experience, particularly in this world, it's very helpful to move away from really broad definitions of confidential information and get as specific as you can. Now on slide 6, what I'm going to be showing you is traditional, customary, super broad definition of confidential information. Now you'll notice, if you look at the first line, that a key clause is not a matter of public record relating to the company. And the problem is the developer doesn't necessarily know what is public record, a matter of public record or not. That language could really create a lot of argument, and particularly because the rest of it is so broad. Knowledge, data, information relating to products, software programs, subroutines, source and object codes, so on. Those are so broad that it doesn't really tell the developer what's in and what's out. And so the agreement doesn't serve the function that you really need it to serve. So I got a couple of, well, first of all, let me tell you how you should think about it. There's generally two kinds of confidential information, very broad terms. One is, does it have some proprietary functionality? And so if it has proprietary functionality that gives you an advantage over your competitors, obviously that's critical to treat as confidential information. But a lot of times the truth is much of the information that you share with the developer does not. So that's one aspect to think about. Another aspect to think about is the data that runs through the software that the developer is going to have access to, particularly where there's an integration with other company software. The issue becomes, is there highly sensitive customer information or highly sensitive company information, data, running through that the only way the developer can do the project you've retained them to do is to end up having some access to that information. Obviously, that also is very important to protect. So I've sort of developed a couple of illustrations so that you can so that I can illustrate my point a little bit better. Let's assume that the company is retaining the software development house to build an accounting module to be integrated with, added on to the accounting software that the company is already using. Well, is the functionality of that software unique or proprietary? Is the type of analytics that are going to be used such that it provides a competitive edge to the company? Maybe yes, but maybe no. In all honesty, a lot of customary accounting software just does what every other accounting software does. But then the other piece of it is the developer going to have to see the company's confidential financial information flow through that accounting software, or employee data flow through that software, or something that in and of itself is critically important to maintaining confidence? So you need to ask that question, and you may come up with a very different definition of confidential information if you're developing this accounting module that is based upon what is really critical to maintain confidence around. Similarly, let's say you hire an app developer. It seems like everybody is developing mobile applications these days. So is what you're asking them to do pretty ordinary in that you're just trying to give customer access over their mobile devices to your products and services? Not any different than what anybody else is doing, not really a big secret. So that part maybe doesn't need to be confidential, but wait, maybe it does need to be confidential during the time period that you are having this developed, because perhaps you're the first one in your industry to take this approach, and you don't want your competitors to know that you're working on this. So maybe that information is confidential until the app is released, and once the app is released, it's like it's obviously public information. It no longer needs to be protected. Or maybe your app has a unique proprietary functionality, and it's really important that the developer keep all aspects around it confidential, because anyone else who figured out how to do this functionality would hurt you in a competitive position. Or third example, and just very briefly, but to emphasize the point, a bank customer interface portal. Well, all banks in the world now have interface portals, so it's not like that's a proprietary idea anymore. But will the developer, in the course of doing the integration, get access to the personal information of the customers and subject them potentially to ID theft? Well, if that's the case, critically important that that part of the information be protected and that you address that in the agreement. So those are illustrations of the type of different scenarios that will result in different information needing to be defined as confidential information.
So Iris, what about information that the developer already knows?
It's a good question, John. And the reality is that most of these non-disclosure agreements have an exclusion, a customer exclusion clause that is within the document itself. And let me move to that slide so you can see an illustration. So you'll usually see excluded information that can be shown by the developer to have been in the developer's possession prior to receiving the information from the company. That one's clear, though not always so easy to prove whether they had it, of course, in their possession before. Another exclusion is whether if the information was in the public domain through no fault of the developer. Another exclusion typically is information that's learned by the developer from a third party, not related to the company, and that third party wasn't under any kind of an obligation to hold the information in confidence, vis-a-vis the company. And then another one you'll usually see is information that's required to be divulged by a valid subpoena or court order, something along those lines. In that case, you'll also oftentimes see a clause that the company negotiates that says, well, okay, but if you do get a subpoena or court order that you feel that you need to comply with, you have to give us notice, an opportunity to go to court and try to get a protective order so that we can maintain that information as confidential as we can, even though we have to, as a matter of legal due process, provide the information. So, so those are kind of customary exceptions. It's possible that other exceptions might end up being individually negotiated, but not generally the case. And then I noted here on the customer exclusion slide open source code, and it's creating some unique situations I've been seeing in recent years. And so I think it's really important for the company, when they retain the services of the developer, to find out whether the developer plans to utilize open source code, because it can change some equations in how you write the agreement and what the parties expect will be happening. And if everybody's in agreement that open source code will be used as a foundation for some of the subroutines or the coding and so on, then obviously that's in the public domain already. It's going to have to be excluded from any kind of a confidentiality agreement. But beyond that, any additional work that's added on top of the open source code might be proprietary. It might need to be maintained in confidence. But the way that the open source community works, as I understand it, is that there's a lot of collaborative online community bug debugging and so on that goes on. So if I'm a developer and I encounter an issue with the software isn't working right somehow, and I want to go out to the online community that is in the open source world and say, hey, I have this problem, anybody seen this before, anybody have any ideas, and so on, which would be customary, then how does that impact the company? And my own recommendation would be in that situation that you at least put a clause in the non-disclosure agreement that would say acknowledge open source code might be used, and would say that if the developer feels a need to reach out to the open source community, that they would let the company know, and that the two of them together would craft the inquiry in such a way as to not divulge any more information to that community than is necessary. It's just an idea that I've come up with in dealing with this.
So Iris, is there any way to be even more sure about whether information should or should not be treated as confidential?
There's one way that I know of, and I have to say, as I talk about it, I'm not crazy about it, but one way is to have any of the media on which confidential information is transmitted to be clearly marked as confidential. And if there's oral disclosures, to have them accompanied by or followed by a written notice identifying them as confidential. And I know some companies really love this approach because, well, all parties like the fact of the certainty. It does create a lot more certainty. I see some real pitfalls with using this approach, primarily administrative in their nature. I think that first of all, it is an administrative burden to think through every time you share any information whether you need to designate it as confidential. And more importantly, there's a lot of failures in follow-through. And so here you are in a situation, confidential information was shared, that confidential information should have been marked as confidential, it wasn't, then what? And it just creates a lot of problems. So I'm generally not a big fan of it, but I always ask the company about their culture and whether or not they would be effective in implementing that kind of a strategy.
So, Iris, what clauses are usually included in an NDA?
There's some really typical clauses, not counting the ones that we've been discussing. Generally, the receiver of the information, in this case it would be the developer, would agree to hold the information that's identified as confidential in confidence, would agree not to disclose it to third parties, would agree not to use it for any purpose other than work on the project. And that actually is the most critical piece. In a way, not using is a little beyond the word non-disclosure, because it is saying, okay, even if you haven't told anybody else about it, if you use it on somebody else's project, for example, you have violated this agreement. And that is the one actually that developers get the most sensitive about, because a lot of times if they've developed something, they don't necessarily need to share it, but they want to use it again for other customers. And so that's an area that will sometimes result in negotiation. There's usually also an agreement not to make copies except as needed to perform the duties. And there's usually an agreement to return all media having confidential information after the project is concluded. Sometimes it says return or destroy. I found that people aren't real good about that follow-through either. And so the company needs to either put protocols in place to make sure that it happens, or face the reality that it may be floating around in somebody's hands sometime in the future.
So what other issues should be addressed in an NDA or non-disclosure agreement?
Well, one issue that I see addressed actually quite often is the issue of a termination date, which I have to say up front I'm not the hugest fan of, but there are a lot of parties that really want it and really insist on it. A lot of lawyers who look at it and say, hey, you need a termination date. So if they want a termination date of the non-disclosure agreement, the most important thing for the company to think about is, when will this information become stale? And in the context of software codes, probably pretty fast, actually, because that world turns around pretty quickly, and information, confidential information, does tend to go stale relatively quickly. In each case, the company has to analyze their circumstances. Where I get really the heebie-jeebies on it is where they have access to confidential information of customers, or accounting information, personal identification information. I mean, let's face it, if somebody has access to personal identification information of a customer, they will be able to do, do ID theft indefinitely. There is no time limit under which all of a sudden no damage could be done. So again, you shouldn't routinely agree to it. You need to think about it first and then decide what to agree to. Another thing that I think is helpful to include, and I like to see included, is a provision under which the developer represents that they're not under a prior obligation, either with another employer, a previous employer, or with another customer, that would restrict their ability to perform the tasks the company is hiring the developer to perform. And this is really important. I think some companies will think, oh, that's the developer's problem. Well, it's not only the developer's problem, because it is possible that if the developer misuses information on another customer's project, on your project, that other customer will sue you for tortious interference with the rights that they had under their non-disclosure agreement. And so I think it's extremely prudent to go ahead and deal with that up front and know whether there's any issues that need to be dealt with. And usually if you include such a clause, the developer will come back and say, oh, oops, I have this agreement. You may want to take a look at it. After you've looked at it, you may decide to find a different developer to work with, or you might find that there's a way that it can be worked out. But it's something that should be dealt with at the front end, not after the fact. And that generally concludes my presentation, John. I don't know if we still have time for questions.
Let's do one more question. Let's do one more question. And here's probably a question that many people would think. What should a company do if a developer refuses to sign a non-disclosure agreement?
Well, kind of goes back to what I was saying before. You have to decide whether or not you can negotiate something that's so carefully crafted that they get comfortable. And that absolutely oftentimes is the case. Or sometimes it's the case that you're just going to have to go find somebody else to work with if you can't work it out. Now, I did have a couple of closing comments, John, that I just forgot to make. And one is I just want to make sure people understand a non-disclosure agreement that I've just been talking about is one piece of the whole pie. And you'll sometimes see non-compete agreements. Non-compete agreements are a complete anathema in the developer community, very hard to get. They're not legal in all states. And as much as they can be attractive and as much as you might like to get the developer to agree not to do put together a similar software for somebody else in your industry, your odds may not be very great. So it's worth an ask, but that's not this document. That's not what we're talking about here. What we're talking about here is making your non-disclosure agreement tight enough that the need for a non-compete agreement is reduced. The other thing that I haven't talked about, and we will talk about, I think, in our second segment of this webinar, is ownership and the proprietary rights. So who owns the technology? Again, I haven't talked about that, but that is another critical piece. So, I think what I want everybody to take away from this is that legal counsel can help you think through these important issues. Off-the-shelf solutions are generally not really advantageous to the company. They will actually typically be more advantageous to the person to whom they're disclosing that information to, and that is one of the reasons that I made this presentation focused on the side of the company rather than the developer. So thank you, John.
Iris, thank you a lot for your time. And Iris has extensive experience in this area, and her contact information will be on the slides that will be provided. Now we're going to move on to our next topic. Sam Frederick is a partner at Foster Swift and negotiates and litigates contracts on behalf of software developers and software users. It's my pleasure to welcome Sam to the webinar audience.
Thank you, John.
Sam will be on in just a moment here. Really, ultimately, everyone is either a user or a developer of software. So businesses are constantly upgrading their systems and signing software contracts, sometimes without even knowing what the contracts really say. Today you're going to help us understand what some of those essential points are. So can you give us an overview of what those essential items or terms in a software contract actually are?
Yeah, the essential terms that you frequently see in any kind of contract are going to be the scope of the license or the grant of the license, the term and termination, the warranties, the indemnity, the ownership, prices, and my colleague Nick tells me to talk about the taxes, but then also the data retrieval or transfer. So those are the frequent terms that you would see in any kind of software contract, whether you're the developer and presenting that contract to a user, or you're the user and receiving software in your business and having to sign some complex document.
So really, why are these items important?
Well, they really control, because they control who can use the software, how it can be used, how long it can be used for, the rights if something goes wrong, the remedy of how do you fix it, and hopefully if something does go wrong, how do you get back in the position you were in before you entered this contract. The terms can appear to be very convoluted on some of these contracts. Some people, it's difficult to understand them, but they oftentimes have severe and sometimes catastrophic consequences. So, I put a me advance this slide here. This, for the viewers at home that are not looking at the slideshow, this is a little cartoon, and it basically the legal department has put together the terms for the software business principle, and the business principle is talking to the lawyer, and the legal department says, hey, these terms and conditions you've drafted us are extremely long and overly complex. Our customers are never going to be able to understand them. Well done, Jones. And, you know, unfortunately, you know, that's the case when you review a lot of these documents, is that there appears to be a lot of you know, convoluted mess to review. And what I try to do is try to demystify and simplify these terms, because if you don't read them or understand them, then you can have problems. In my last little comic, I promise this isn't a slideshow of comics, but this is my last comic of you know, a couple sitting with their contract and the devil walking in, and the lady saying, "Oh dear, did we neglect to read the contract thoroughly?" And it, you know, it kind of summarizes the point that the devil's in the details, and unfortunately, that's the case with a lot of these software contracts. So that's what I'm going to talk about today. And talk about these software contracts and the essential terms, and try to, you know, ferret out some of these details that can have catastrophic consequences. So the primary contracts that you're going to see deal primarily with three sets of software. You have off-the-shelf software, which is, you know, that's your Microsoft, that's just common software that's being used. It's not being customized for your organization. Then you have this customized software, which is kind of a hybrid of software that comes out to a business, and they customize it to your needs. And then you have this concept of custom software, where software is actually being developed either jointly by the business and the developer, or by the developer for someone or some other industry. So there's, in those contexts, you know, of off-the-shelf software, customized software, custom software, whether you are the developer, you know, that's actually created this stuff, or you are the user that, you know, you're using this, and you can, oftentimes you're referred to as the licensee, you have these common software agreements. And so, you know, for in the sake of fun, you know, later if you wanted to dig out one of these contracts, it would most likely be, you know, a software license, a master service agreement, a software as a service agreement, which is basically, everybody remembers you used to get CD-ROMs in the mail. Well, now it's all just hosted in the cloud, and they came up with a funny little acronym that is software as a service. Then you have the license agreement. You also have a software maintenance and service agreement, which is really a tag-along agreement of how we're going to maintain and service the software that we just sold you or licensed to you. And then you have this EULA, which is the end-user licensing agreement. You often see those in, they were shrink wraps, and now they're click wraps, where they require you to click on their terms before you begin using their software, Gmail, Yahoo, that type of thing. Has some EULAs. So let's move forward. So with that context, these are your typical agreements that you're using. If you're going to be acquiring software, this is the governing documents that are going to be itemized and named. And then we get to, well, what are these typical terms? As a user of software, what are the typical terms that we're going to see? And the typical terms that you're going to see, and really that you should be concerned about, is the opening term. And I encourage everyone to get out a copy of their agreement. And kind of go through this, and because you're going to find at the beginning of the license agreement, you're going to see the grant or the scope of the license. You're going to see the term and termination. How long does it last? How does it end? You have the warranties, which say that we're going to do this, and then we have the disclaimers, which say, we're not going to do this, and everything we said before, we're not warranting now. And then you have the indemnity provision, you have the ownership, you have the issue of price, you have the issue of kind of miscellaneous provisions and taxes, which my colleague Nick Ortel is going to address. So let's just march through each one of these terms, because really these are the essential terms that can go one way or the other to enhance or limit your rights. And so when you're negotiating to sell or to acquire software, the issue is, what is the scope of this license? And the scope really goes to the use of the rights. How many people are going to be able to use this? For what specific purpose are they going to be able to use this? That's important because you, as an enterprise or a business, may be seeking software, and maybe you have offices in multiple locations, and maybe you have offices in multiple countries. In that case, the geographic area or the scope of the license is going to be important. You're going to make sure that you would hopefully have worldwide rights, or at least North American rights. So you want to be able to address that and make sure that that is addressed accordingly to your specific needs. And then lastly, I have, if a license is limited in scope and the licensee acts outside the scope, the licensor can bring an action for copyright infringement. Well, what that basically means is the licensor is the person that's selling, which is really licensing you the software, and they're the owner in this circumstance. And if you have users that are not listed, or you exceed the number of users, if you're using it outside of the scope of your license, then you're in violation of your license, and the remedy for that is in part a copyright infringement. So they can sue you if the scope of your if you're exceeding the scope of your license. So that's why the scope of the license is also important. So after you've figured out, okay, well, what is the appropriate scope, then of course you need to really determine the term. And if you're on the developer side, this is a pricing issue. You want to figure out how long you want to give access to the software based on the price. If you're on the user side, you really want to evaluate and see how long your business needs this software. And that goes to the time period or the term, usually beginning on what's referred to in the contract as the effective date, capital E and a capital D. And then the renewal. You should address the renewal as a user when you're acquiring software. How long do I get to use this? Is it forever? We've paid $100,000 for this. Do you mean to tell me we only get this for 6 years? You should know that. You should know whether or not these provisions, these time periods, automatically renew. Maybe this is new software. You're not sure about it. You want to spend a year, but you see that there's an evergreen provision, which is just this reference to these terms that keeps renewing year after year after year if you don't say that you want to terminate it. Maybe that's good. Maybe that's bad. That's a business decision that you need to evaluate. Again, that's in the details. And then I put in bankruptcy of the licensor. This can be important. The bankruptcy code, without getting too technical here, the bankruptcy code tries to treat the users of software pretty well, but if your developer goes into bankruptcy, or your licensor, or the person that's selling you the software goes into bankruptcy, they can terminate your contract, and you can sue them for damages, and that sounds like a lot, but really they're in bankruptcy, so you're not going to get a lot. The other option is that you can petition to continue to use this software for the term of your agreement. So maybe if the business is a little shaky, or you're uncertain, maybe you want a long time period at the beginning because you want this software, whether or not this company is going under or not. So let's just keep moving. So those are essential terms on the term of the license. Then we get into this concept of, is it exclusive, is it not exclusive? And I have here, non-exclusive permits the user to use the software, but also allows the vendor to license the same software to others. Non-exclusive, what you got to remember is that it's for other people. Non-exclusive means that it's for others. It's not just for you. Exclusive license means it's just for you. Typically, an off-the-shelf software, it's non-exclusive, and so you and everybody else is going to have a right to use it. As a developer, you might want to consider whether this is exclusive or non-exclusive. If it is an exclusive from a developer's point of view, you're going to want to charge a lot more because this is the only time that this software is going out and being commercialized. Now, on the user side, if you've paid gobs of money for something and there's a little bit of R&D in that software, you may want to make that exclusive so that developer cannot go and say, hey, we got this great product or the software and we can now sell it to all your people that you're competing with in this niche market. So it's good to know whether it's exclusive for you only or non-exclusive. Everybody can acquire the software. And so then we get into some of the other kind of fun aspects of the software license agreement. Frequently, as a user, when you're acquiring all this software, it's the greatest thing. It's going to do wonders for your organization, and there are no wrongs. And then you get to the agreement, and the agreement says we don't warrant this, for bombs, bugs, Trojan horses. If this crashes your system, we're not responsible. And if you have even read that far in the contract, you think, wow. So you would like to have some sort of middle ground in the agreement that they would warrant that it's not going to, or that they don't know of any, that it's been tested at least, and so you can try to seek a middle ground. But again, devil's in the details. That's a big one, because if it crashes your system, the software's been integrated in your system, it crashes, they're usually not responsible because they've put a provision in there that says they're not responsible. The next one is software audits, and software audits, it allows the vendor or the developer to come in, and you said that you were going, based on your pricing, you needed 25 users. Well, they come in and they check that out, or they monitor it and they make sure that you're within that 25 users. If you're using 75 users on a 25 user payment plan, then that goes to our previous slide about copyright infringement and being sued. So you want to watch that the software audits, that you're following that, and you're agreeable to that, and that your employees are following any kind of restrictions that you would have for the number of authorized users for that software. And then the next slide that we get into is we just march through this software agreement. We've dealt with the term, the scope, the term, termination. Now we get into these representations and warranties, and we get into this is are you on the user side or are you on the developer side? On the developer side, you really don't want to warrant anything. You give this software as is. You've tested it. You kicked the tires. It doesn't crumble. It does what it should do to the best of your knowledge, and you should be able to go out and commercialize it. But on a user side, you've had the sales rep come out, you've had demonstrations, you've had all these, glossy materials that you reviewed, and this is the next big thing. And then you get to the contract, and as we say in the bottom of the disclaimer of warranties, none of that applies. You know, when you get to sign the agreement, there are no warranties, essentially. And so what I like to do, you know, with some of my clients is talk about the warranties, you know, in this concept, and I guess I'll simplify it, is that the software will perform in accordance with the written documentation provided. That really gets you whatever they said they were going to do. And that allows you, as a user, to say, look, we thought it was going to do X because you said it was going to do X. That was the basis of our decision that we bought this software. So it should do X, and if it doesn't, then we get our money back. And a lot of this software I'm seeing now is that, you know, it's upfront payments, and then they come out, then they integrate, and you've already shelled out $100,000, and it might just not work the way it said it does. So your escape hatch is a single sentence that this software will perform in accordance with the written documentation provided. And I tell you, by real experience, that single sentence has got me or my client $100,000 back in their bank account. And we went and got different software. So it's a powerful idea of warranting and having those details appropriate. The other thing that you get into is this disclaimer of warranties. Is after, you know, you try to get warranties that they say they're going to do this, you get into what many developers would call a disclaimer of warranty. And I've copied and pasted, you know, for educational purposes only, of course, Cisco's disclaimer of warranty. And I can assure you this is where the devil in the details resides. Because as you read this, it says, we are not going to warrant anything. Merchantability, that means basically that this stuff works generally. We're not warranting that. Fitness for a particular purpose, that it works for your situation, we're not warranting that. That it doesn't interfere, we're not warranting that. That it doesn't do what, you know, the satisfactory quality, we don't warrant that either. That it's accurate, we don't warrant that. So, you know, this is kind of problematic, right? Because this is a little different. Had they pitched this to you, you probably wouldn't have bought the software. But at the beginning of the sentence, you can kind of change the balance of power. They have 4 words after except as. It says, except as specified in this warranty section. So what that basically means is, unless it says otherwise in this little section, then everything else is out the window. It doesn't matter what our sales rep told you. It doesn't matter what the people that came out to do the integration told you. This is the be-all and the end-all. Well, what you can do is replace the 4 words after except as with 2 words and say except as otherwise provided. And then you've made modifications in other parts of the document. Remember, we said the software should perform in accordance with the documentation. Now it's provided otherwise. So that warranty then, you know, is in place, and Cisco's lawyers or their lawyers can still go back and think they have, you know, the general gist of all their disclaimers. So be cautious of the disclaimer of warranty. Be very cautious of the disclaimer of warranty. All right, so moving on, we have limitations of liability. So after, usually in the contract, you have this idea of warranty, then they disclaim the warranty. And then if there's anything left, they said, well, you know, we're probably going to limit our damages too. And as a user, you know, that might be somewhat acceptable, but make sure you know what the damages are limited to, if at all. If it's going to be limited to twice the amount of the contract or only the amount of the contract, as a user, why not have that be a mutual provision? The most that we're liable is the value of this contract, nothing more. There's some issues with limitation of liability depending on the the scope of the software and what you're using it for, whether that's a good idea. But, you know, that's something to be very, very cautious of and review. So that's limitations of liability. Now we get into ownership.
Okay, Sam, can I just interject here on the subject of ownership? A lot of people say that if they pay the fee, they are the owner of the software. That's not always the case, is it?
No, and I've probably perpetrated that myth a little bit here by saying when you buy the software, because you don't really buy the software. You're licensing the software. You're renting the software. You're leasing the car, not buying the car. And in software, 9 times out of 10, as a user, you acquire a license, which is a right to use the software for a fee. You don't own it. And the only way you can own it as a user, if you have not created it, is this concept of Copyright Act, which we see on the slide, which is a work made for hire. Let's say you're an organization and you want some custom software for your business. Well, let's say you're going to pay $200,000 to this great developer. Well, that developer, absent a work make for hire or an assignment, is the owner of that software regardless of how much money you've paid them, unless in the contract you specify that it transfers. And if a work made for hire, if it's not in writing, you want to go back and you've spent a lot of money on this project and you're hearing this webinar now and thinking, oh my gosh, we don't own the software and we spent $250,000, how are we going to justify this at the end of the year? You can do a one-page assignment and just transfer it over if the developer will sign it. The other thing is this idea of derivative works, and that is, let's say buy some software. Again, you're not buying, you're leasing, sorry, but you're acquiring this software and it's being customized for your organization, and you think and you get into it and you think, you know, we can really enhance this, we can make it better than it is. We can make a version that derives from the original. In that case, then you're dealing with a derivative work, something that derives from the original, and you cannot do that. And the most simplified method that I can explain that concept is that, you know, think of the developer as creating Back to the Future 1. If they've created Back to the Future 1, you cannot do version, you know, Back to the Future 2 or 3 or 4 or whatever. That's theirs. Anything that derives from the original is theirs, unless you get an assignment or work made for hire. So that's the copyright, that's the ownership concepts. There is this issue of sublicensing. I'm going to cruise through this issue, but the sublicensing, make sure that your organization, all of your organization, has the right or access to the software. If it's an affiliate, it may not be covered, but you may be able to sublicense the right to them. Iris Linder talked a little bit about you know, the interesting case of open source software, and in technology contracts, and specifically software agreements, there are specific provisions that may and may not be included. So be cautious if you see that the software is created open source. Make sure that those warranties are actually in conformance, because there's do a whole webinar on the difference between open source software and traditional software. So just wanted to put that in there as a flag. So the next item, as you're kind of moving through going through the terms of a software agreement, you know, we talked about these master software agreements and the software as a service agreement. Well, this is the maintenance and updates. This is the tag-along part of the contract, which is really a separate contract that says we're gonna fix it, we're gonna manage it, we're gonna maintain it, and we're gonna update it. And a lot of the times the terms are very similar. So just because you made changes in the master agreement or the license agreement,
it doesn't apply to the maintenance agreement, so you got to go and make sure that those terms are included in the maintenance agreement. Well, but as a user, what you should really be considering is on this maintenance agreement is, are they going to maintain this? Are they going to keep this up to date? Is this going to be obsolete next month, next year, in 2 years? Service credits, if they're not performing, the software goes down. You're paying them all this money to maintain it monthly or quarterly. You should probably get some money back for, it's like if Comcast goes out for a week, you probably shouldn't pay, the 4 weeks of your cable bill. You should just pay 3. And then the term, how long does the term last? Should they be available? The people should be available. It's the hot help desk. How frequently should they be available? That should all be addressed in the maintenance agreement. So the last few items, and we're just going to kind of move through these as we close out here in our last 5 minutes, is the pricing. You really want to determine the pricing. The pricing may not be in the body of the agreement, but maybe an attached schedule. And rather than pay it up front, the entire amount up front, you may want to pay with milestones, when milestones are met, partial payments. You're going to pay half up front, and then once it's tested and goes live, then they get the rest of it, something like that. The other issue, which is a real concern when you're dealing with customized or custom software, is this issue of source code and doing an escrow of the source code. This can be catastrophic for a user who does not do a source code escrow. If you as a user are hiring somebody to build you software that you're going to commercialize or use, and something happens in that relationship between you and the developer, and it goes south, yeah, your contracts say you can go into court and sue them for this, and they can sue you for that. But guess what? You got to go to court and you got to sue them, and you don't have the software, and you can't jump to another developer with what's already partially completed because you don't have the software. So you got to go to court and fight about damages and try to get your hands on the software. So what I would absolutely recommend is you do some sort of source code escrow, where the source code, as it's being completed, is placed in the separate area, and then if there's any problems, you either have immediate access to it upon certain payments, or you do have access as it's being built. So moving on to assignment of rights, this is kind of closes out the contracts. When you're getting to the end of a contract, you're going to see all these miscellaneous items as we discussed at the beginning. The one thing to keep in mind is, as a user, you may not want the developer to be able to assign their rights, because after all, you hired the developer to do it. But maybe the developer needs to be able to hire subcontractors. The other thing is, and this is one that actually some companies get stung by, is that there is not an assignment provision for the company or the user. So if you as the user enterprise are using the software and you're sold, that's great, or you do some sort of corporate restructuring, then that license, unless it specifically says that it can be assigned, is not assigned. So guess what? You got to go back and renegotiate with the licensor a new contract. That's not so great to do. Modifications, as we're closing out the last couple slides, the modifications can be expensive. They should be specified. You should have timelines, benchmarks, guideposts, and payments to match those benchmarks. Iris Linder talked about trade secrets and confidentiality. Those provisions are very important, and they should survive the termination or expiration of your traditional license agreement. And then finally, as we just kind of wrap up in these miscellaneous portions or provisions of the law, we have this idea of choice of law. You know, it'd be great if the choice of law is in Michigan, or if you're a New York company, or wherever your company resides. That would be helpful. Disputed payments, when you're having payments, you shouldn't have the lights turned off because you miss a payment or you're disputing a payment. So you should make sure throughout the agreement it's consistent that any payments are required for undisputed amounts. That's a big one. It's an easy one, but it's a big one. You should also have an issue for data transfer. If you've transferred data to this software and you're dependent upon it and the relationship ends, you should be able to get the data transferred back to you at no cost or at some sort of reasonable cost, but that issue should be addressed, as well as if during the term of the relationship there is some sort of breach to the data, that the company managing that software is supposed to take some actions. So, really in 26 minutes we've screamed through a 40-page software contract that is been convoluted, and we hope we've demystified it a little bit. Hopefully you can manage some of these devils in the details better, soften the consequences, and enhance your rights. But I would say always remember it always or should be negotiable. So thank you.
Thanks a lot, Sam. And as well for Iris, Sam's contact information is available on these slides, and it will be available in the follow-up information as well. And in conclusion, Sam has drafted and litigated many of these types of contracts, so he has extensive experience dealing with all types of software contracts in this context. So now we're going to move on, and as our next presenter gets ready, I just want to provide a few reminders. Number one, we're going to be sending you a follow-up email with the slides, so if you want the information that's on the slides, you don't have to take notes or you don't have to write down what's on the slides. You will be receiving an email with these slides, and you will also be receiving some additional takeaway points that can summarize the vast amount of information that you're getting access to right now. And so now I want to introduce our next speaker. Nick is an attorney with Foster Swift, and he has experience with the tax issues relating to technology. So we know everybody loves tax and discussing tax and learning about tax issues. And so now I want to welcome Nick to this webinar.
Thanks, John. Yeah, buckle up, everybody. We're going to be talking about tax, so it's going to be real exciting here. But we've listened to Sam and Iris go through and talk about the different issues that a business or a developer needs to be aware of when they're developing software. But let me transition a little bit into some of the tax aspects that they need to be aware of as well when they are selling that software or licensing or leasing the software. So specifically, when we're talking about the Michigan sales and use tax, Michigan has multiple taxes that a business owner needs to be familiar with, but sales and use taxes are some of the most important. So, and let me give just a quick overview too about where I'm going to be going with this. So I'm going to give you just a general framework of what sales tax is, what the use tax is. I'm going to talk about custom software and then pre-written or canned software and how those two differ from a tax standpoint. I'm also going to talk about the industrial processing exemption, which can provide a tax exemption for businesses or individuals that are engaged in developing or manufacturing software. So that's important for for lessening the tax impact. I'm also going to touch briefly on cloud computing and software as a service and kind of how those are subject to tax. And lastly, I'm going to just touch on audits and how those work and some key things that you need to be aware of if you are subject to an audit. So let me jump in here and kind of give a brief overview of what the sales tax is. So I think most people are familiar with the sales tax. We've all gone to the store, purchased an item, received a receipt, and looked at the very bottom and seen that there is an item on there for sales tax, and it's you're paying 6% on something. So let's talk a little bit about what that is. So Michigan has a sales tax, and the sales tax is basically a privilege tax for the right to sell goods at retail in Michigan. So the sales tax actually applies to the retailer, but the retailers will usually pass the tax on to the buyer. And it only applies to retailers with nexus in Michigan. So nexus is basically a fancy word for location or some sort of legal connection to the state of Michigan. So it's usually that means that a retailer has an office in Michigan, or maybe they have employees in Michigan. But to be subject to tax, there has to be nexus with Michigan. So that's the sales tax in a very brief nutshell. So let's jump to the use tax. Most people probably have heard of the use tax, but aren't familiar with what it is and really how it works. So the sales or the use tax is really the mirror to the sales tax. So the use tax is also a privilege tax, but it's a tax on the privilege of using, consuming, or storing goods in the state of Michigan. So unlike the sales tax, the use tax applies to the consumer, and consumers are required to basically self-report use tax on their annual tax returns. So, well, except for some big ticket items that really aren't relevant in the software context. So you self-report it, and it's mutually exclusive with the sales tax. So what that means that is, if a transaction is subject to sales tax, it will not be subject to use tax. That's a general statement. The Department of Treasury continually challenges that, but there is case law supporting that. I have litigated and won on that issue. So that's a general statement that's usually correct. So okay, let me jump slides here, and I think that just before we delve into the little bit more of the details on what the sales tax is, what the use tax is, how they plug into the software context, I think it's helpful just to give an example, a very, very simple example of the differences between sales and use tax. So in example one, let's assume that somebody, a purchaser goes into his local big box store in Lansing, Michigan, and buys a $1,000 TV. So what's the tax consequence? Well, we said earlier that the sales tax is a tax on the retail sale of goods. So in this case, there is a retail sale. We said it applies to retailers that have nexus in Michigan. Okay, this big box store has an office in Lansing. So that means that the sales tax is going to apply, and the retailer is going to pass it on to the purchaser. So that's the sales tax in a very basic nutshell. The use tax can be illustrated by the second example here, which is that same purchaser wants his TV, but instead of buying it from his local store in Lansing, he logs onto his computer, goes to, for example, Amazon.com, and buys it from Amazon. Okay, so what does that mean? Well, Amazon doesn't have nexus with the state of Michigan. They don't have an office in the state of Michigan. They don't have a building in the state of Michigan. So that means that there would not be sales tax on the seller. So what's the tax consequence? Well, we said earlier that the use tax is the mirror to the sales tax and covers those transactions that escape the sales tax. So in this case, the buyer, the purchaser, is going to have to report use tax on his or her annual tax returns to the state of Michigan. So moving on to the next slide here, just a little bit more detail on the nuts and bolts of the sales tax. So we said that the sales tax is a tax on retail sales, and the key to it is that it has to be of tangible personal property. So tangible personal property is really broadly defined, and in a slide or two we'll get into what that means in the software context, but suffice to say that it covers pretty much pretty much any sort of good or item that you really buy. So so that's that's what tangible personal property is defined to mean. Sale at retail basically means that it's to the end user. It's not a wholesale transaction. And an important note as well is that the sales tax is not levied on services with certain limited exceptions. So that's an important point to keep in mind as well. The tax rate is 6%, and as we said, it's the burden of the seller. Registration, there's a little bit of information on here. I'll just gloss over it on registration. But if you are in the business of retailing software, or you've developed software and you're going to be selling it to end users or licensing it to end users, there could be sales and use tax consequences. So you would need to register with the state of Michigan and remit tax payments. It's pretty easy to register. Your CPA or certainly your attorney could help out with that, but it's either paper filing or registration via an online portal. So let's move on here and talk about sales tax in the context of custom software versus pre-written computer software. So this is definitely a big takeaway. That this is kind of my top 3 takeaways that I would kind of note for the listeners here is that there's a big difference from a tax standpoint. Okay, custom software is not subject to sales tax. So if you have developed custom software and you have licensed it or sold it to the purchaser, that transaction would not be subject to sales tax. Pre-written computer software, on the other hand, is subject to sales tax. So the obvious question at this point is, what is the difference between custom software and pre-written computer software? Okay. Custom software is basically software that is originally designed for the exclusive use and needs of a particular purchaser. So that definition is really important because it has to be something that's designed for a particular person and for the exclusive kind of customized needs and specifications of that person. So there's infinite examples of what custom software could be. Could be a custom inventory system, it could be a custom contact management system, but the bottom line is that it has to be developed or manufactured for the specific needs of a specific purchaser. And in contrast, pre-written computer software or canned computer software is basically software that is developed for that is not developed for a specific purchaser. It's it's developed for the masses. It's sold to the general public. It's your Microsoft Office suite of Word, Excel, or anything like that. Maybe it's a mobile app or something like that you're developing that's not for some specific purpose or some specific person, but it's just for the masses. So that would be pre-written computer software. Now there's 2 caveats to that. Sam mentioned back in his presentation customized software, which is kind of a hybrid where somebody takes pre-written computer software or canned computer software and maybe tweaks it in some way to make it meet a particular purchaser or a particular user's needs more directly. So in that case, it's important to itemize on the invoice that purchaser receives the costs that are associated with that customization or that tweaking of the canned software, because those costs can be excluded from sales tax because they're essentially services, and we noted that services aren't subject to sales tax. So if you're taking pre-written computer software and you are changing it or modifying it for a particular purpose, for the particular purpose of a particular person, then you definitely want to itemize those costs out. And the second caveat is just that sometimes developers end up developing some sort of software that's initially designed to be custom software. Maybe there's initially a particular purchaser for it, and it's designed for that particular purchaser's needs, but for some reason the deal falls through, or maybe it's eventually maybe it eventually ends up being sold to the masses later down the road. So in that case, those situations would likewise be canned software. So let me move on here. So we've talked about what the sales tax is, what the use tax is. We've talked about how custom software isn't subject to sales tax. We've talked about how customized software, that canned software that's later modified, can be kind of the costs associated with that modification can be excluded from sales tax. And then we talked about the flat rule that canned software or pre-written computer software is subject to sales tax. But let's talk a little bit about the process of developing or manufacturing that software or that application, and how that fits into the sales and use tax scenario. So if you're a developer and you are developing software, and you bought goods, and maybe you bought computers, or you're buying some sort of hardware that's used in that process, and it's really important for you to be aware of the industrial processing exemption in the state of Michigan. So this basically provides an exception from sales and use tax if you are using goods for the development of software. So as I said, it could be computers, it could be utilities that are used in the process of developing. So it's really important to be aware of that. But there's one important caveat that you need to be aware of if you're thinking about utilizing the industrial processing exemption, and that is that the industrial processing exemption will only provide you an exemption from sales or use tax if you are developing or manufacturing canned computer software, okay? Because the point of the industrial processing exemption is to avoid double taxation. So if you are using goods or computers, or incorporating them into the development of your software, then they shouldn't be taxed up front and then taxed again when you sell the software. So it only applies if you are it only can apply if you're manufacturing or developing in the canned or pre-written software context. If you are purchasing items that are used in the development of custom software, then the industrial processing exemption is not applicable. So, and if you are a developer and you think that the industrial processing exemption might be applicable in your business, then you need to get an exemption certificate from the state of Michigan that basically you present to sellers when you are purchasing items, computers, hardware that might be subject to the industrial processing exemption. So you show it to the seller, and then they know, hey, we don't have to charge this guy or this developer sales or use tax. So let me move on to kind of a couple topics that are growing in importance in the IT context, and that is, and one of them is cloud computing, and specifically, I mean, there's multiple types of cloud computing, but the big one that I want to talk about is a type of cloud computing known as software as a service. So if you aren't familiar with software as a service, I'm sure that you are, but kind of the canned definition is a software delivery model in which software is hosted in a remote data center and provided to customers across the internet. It's often referred to as on-demand software. So basically, some common examples of software as a service would be your Citrix application. If you have Citrix, I use it regularly to log in remotely from the office, and you log on to Citrix and you access your suite of Microsoft software and and a lot of other software from that, and so that would be a common example of what software as a service is. So the question that you run into is how is software as a service taxed? And as is the case with a lot of things involving kind of new frontiers in technology, they often, and in this case, they end up getting ahead of the tax regime. So there's no clear guidance on how cloud computing and specifically software as a service is taxed. But let me note a couple things. You know, we're presenting this from the state of Michigan. I'm sure that a lot of our listeners are in the state of Michigan, and Michigan has currently has two bills that are currently before the legislature that would resolve this problem, or at least provide guidance on how it's taxed. So Michigan is contemplating passing legislation that would exclude from the definition of tangible personal property, i.e. it would mean that sales and use tax is not applicable if someone is accessing pre-written computer software that is stored on the server of somebody else, basically. So it's, you know, you're logging on. I'm logging on to my Citrix account, and I'm accessing Microsoft Word, you know, stored on, you know, a server located who knows where. This would provide, you know, clarification that that specific type of transaction wouldn't be subject to sales or use tax. Now, that's not the law. That's only legislation. This was proposed before. We don't know if it'll pass, but it's definitely something to stay tuned to. Now, there's going to be other issues that come up in this context because, you know, for example, what if the server's, you know, located in Michigan? Would that still apply? You know, and there's other questions as well. Sometimes software as a service ends up kind of straddling that line between what is tangible personal property, i.e. subject to tax, and what is really a service. So there's a bunch of questions that you end up running into on this, and it's something to be aware of if you run into you know, cloud computing issues and software as a service issues. And we'll just have to kind of sit tight and, you know, wait for the tax guidance to catch up with the technology, which sometimes unfortunately takes you know, a little longer than we'd like. Let me actually, while I'm talking about software as a service, let me talk a little bit about another topic that is probably more familiar to everybody than even cloud computing and software as a service, and that is internet sales tax. So this is always a hot topic, and you know, we've all gone online and bought something, and, you know, we've gone to our cart, punched in our credit card number, and, you know, got the receipt, and we noticed, hey, there's no sales tax. This is great, you know, and, you know, so we end up doing all of our shopping online so we can avoid sales tax. The first question is, why is that the case? And the reason for that is that the reason that, you know, sometimes you go online and you buy something and there's no sales tax. The reason for that is that the Supreme Court has held that states can't impose their sales tax or tax regimes on retailers that don't have nexus that we talked about earlier. So in order for a state to impose its taxing will on a retailer, that retailer has to have nexus in the state of Michigan. Okay, so that basically means connection. So when you end up getting online and you know, buying something, oftentimes these retailers don't have nexus in Michigan, so they don't have to remit sales tax. Now that begs the question: is it really a tax-free, you know, purchase? And the answer to that is no. You know, if you log on to, you know, if you get online and you know, you buy your TV and there's no sales tax on it, you still have to pay use tax on it. But the problem with that is that it's difficult to enforce the use tax, and it's, you know, notorious. You know, not that people are, you know, necessarily scheming or intentionally breaking the law, but most people just frankly aren't aware of the sales tax and wouldn't know how to go about reporting it anyway. So it's something that states are losing out on billions of dollars. I think the estimates are roughly around $23 billion in lost revenue, you know, in 2012 alone. So there has been a cry from brick and mortar retailers that do have to remit sales tax to kind of even the playing field. So there is constantly news going back and forth about kind of what is the solution for this, and right now the big thing is a federal solution to the internet sales tax quote unquote problem, and there's no answer to it yet. But what's been kicked around is basically having a federal framework that makes online retailers comply with the sales tax laws of the states in which they make sales. So obviously that would raise questions about whether that's feasible or overly burdensome, but that's kind of where we're at on it. So this again is just like cloud computing is an issue that has ended up becoming much more prevalent in recent years as far as online shopping, and the tax aspect and the tax rules for how to remit tax, or whether a transaction is even taxable, or whether it's even taxable, haven't caught up. So we'll have to we'll just have to kind of sit tight and wait for some sort of framework to emerge on that. Okay, so let me move on to one final topic here, and if sales and use tax hasn't put you to sleep yet, then I'm sure audits will. But that being said, it is very important to know if you're a developer and you are starting to you develop something and you're selling it, you need to be aware of number one, that you need to comply with the sales and use tax laws of the state that you're in, and number two, you need to be aware of that the fact that the taxing authorities frequently audit for sales and use tax compliance for many reasons. Number one, tax revenues from other sorts of taxes, for example, the income tax or the property tax, don't provide the revenue sources that they used to. So states are kind of looking to reallocate how they audit businesses, and sales and use tax compliance is a really big area for them. So it's something that you definitely need to be aware of. And before I jump into it, I just want to touch on one thing, which is this is definitely another takeaway, is that if you're a developer, or you're the owner of your business, and you're out there selling or licensing software, then you need to be aware of, number one, that you have to pay sales and use tax, but number two, you need to be aware of that officers can be held personally liable individually for failing to pay sales and use tax. So basically, if you are the person at the business responsible for filing the sales or use tax returns, then if they're not filed, or if there's some sort of drastic underreporting, then you can be personally liable. And obviously, if you're the sole owner of your business, or if you're the developer that's got a few employees and you're the key employee, that officer who's liable is likely going to be used. So that's definitely something to be aware of. So as I said, let me jump back to audits real quickly here and just buzz over a couple things that they're kind of need-to-know things about how the audit process works. Number one, usually the look-back period for an audit is 4 years, and the reason for that is that is the statute of limitations for violations of the Sales and Use Tax Act. That's a general rule. Now, if you don't file your sales and use tax returns, or there's some sort of drastic negligence or intentional wrongdoing, then there's a longer statute of limitations. But generally, the Department of Treasury and the auditor will come in and they will look back for 4 years. So the auditor is going to come in, they're going to review all of your records, excuse me, they're going to review your records, your receipts, possibly talk with employees. So it's important if you're the business out there engaged in licensing or selling software, very important to keep accurate records, accurate receipts, because if you don't, there's a presumption that the facts are basically in favor of the Department of Treasury, which is not a good thing. So you got to keep those records and make sure you have them. Okay, so they're going to look through your records, they're going to come back, and at the end of the audit, they're basically going to tell you either, hey, you got a clean bill of health, or B, you owe taxes. And if you owe tax, they're going to apply interest on it for about 4.25%, and they're also going to apply a penalty of roughly 10%. So important to important to comply with the sales and use tax requirements. And at that point, all is not lost. You can either agree and say, my bad, we should have done it. Here's your check, or you can say that, yeah, you know what, we don't agree with you. Maybe you're misunderstanding the fact that what we're really selling is custom software, or maybe we had an industrial processing exemption for some of this stuff, or maybe there's some sort of other exemption that the Department of Treasury didn't catch in their audit, and we're going to challenge it. And there's there's ways to challenge it. I could go through here and kind of run through them, but let me just point out a couple key points. When you get the preliminary audit determination letter after the audit's done, and if you're going to challenge it, contact an attorney who is knowledgeable in sales and use tax requirements and audits, because there's time limits that begin to run around that period. So generally you have 60 days to kind of request what's called an informal conference. You go before a referee, you pitch your case to them, and hopefully they agree with you. And if they don't, again, all is not lost. At that point, you have another 35 to 90 days to appeal to the formal tax tribunal or court of claims. So anyway, without going into really any more detail on what audit process entails, I just want to stress, number one, make sure you file and you comply with the requirements, because if you don't, you could be held personally liable. Number two, once you're involved in an audit, and once they get to the process where they've concluded, make sure you promptly contact your tax advisor, whether that's your CPA or attorney, because there's restrictions and time limits on appeal. And number three, make sure you keep accurate records, because if you don't, it's going to be difficult down the road to prove that there was some sort of exemption, maybe for industrial processing, as I said, or some sort of other reason why the tax should be either eliminated or reduced. So those are the big takeaways that I just want to stress, and that's the end of my comments on this.
All right, thank you, Nick. Tax law can often be one of the most difficult areas, so thanks for providing some clarity on those issues. Now, just as I mentioned earlier, each speaker's contact information is on the slides that will be emailed to you in a follow-up, and in addition, some takeaway points will be provided as well. Also, I want to welcome you to visit the Technology Law blog, which all of these attorneys contribute to, and the address for that is michiganitlaw.com, michiganitlaw.com. We did record today's session, and the recording will be posted on the Technology Law blog within the next 24 hours. And finally, if you found this webinar helpful, please share this information with your colleagues and register for Part 2, which will be 1 week from today, next Wednesday at noon. Next week's session will cover how to secure intellectual property rights so people hopefully can't steal them, and also litigation and enforcement strategies, which can be extremely important. So thank you for attending. Look for the follow-up email and have a wonderful week.